Hello everybody, this lecture is going to be about being negative on the personhood topic. Lee went over our affirmative last time in the squad meeting, and now I'm going to go over being negative. So to overview the lecture, I'm going to talk about the resolution and then strategies you can run no matter what the case you're debating is. Then what we're going to do against AI, right to nature, and non-human animals. Well, I skipped past the resolution, but the essence of the resolution is that the affirmative has to grant rights and or duties to either artificial intelligence, non-human animals, or nature. Those are the three areas you're going to have to debate. And what we can run against anything is we can run our fetal personhood disad, which is also called the spillover disad, which is what we're going to spend a lot of time talking about, and we can always run topicality. So for the fetal personhood disad, whatever entity they grant rights to will be used as an excuse for conservatives to grant rights to fetuses. So our argument is that conservatives want to grant rights to fetuses, but they don't have the precedent by which to do it. I'm sure you all are familiar with the idea that Roe versus Wade, which granted women the right to have an abortion, was overturned this summer, and that has been thrown back to the states. And so now there's a big debate at the state level, which could come at the federal level, as to how far we go with the new precedents. And our argument is that the fetus would be granted personhood at conception. That's what conservatives want to do. And if you granted personhood to, say, artificial intelligence or non-human animals or to nature, that it would set a precedent for conservatives to say, hey, we granted rights to non-human animals, we should also grant those rights to fetuses. Our argument is this would crush pregnant people's rights and lead to war. So a couple of things there. First of all, there are a lot of restrictions if the personhood begins at conception that are placed on people who can become pregnant. For example, 1, you couldn't have an abortion. 2, you couldn't get in vitro fertilization because that requires the creation of an embryo in a test tube, and that means that you wouldn't be granting the fetus personhood at conception. And this kind of action leads to war, and the reason why it does is that there is a huge amount of studies that's been done that says that gender inequality in countries leads to a higher degree of conflict. Now you might be asking, why did I say pregnant people and not women? This makes sure that we're open to trans people. So for example, a trans woman, someone who is born a male but identifies as, who is born a female but identifies as male, could still become pregnant. And we want to make sure we're not being transphobic with our argument. And so that can become an issue in debates, and so we want to make sure we're talking about pregnant people and not just biological women who identify as women, because there may be someone who is a biological woman who identifies as a man but can obviously still become pregnant. In the drop box, this is found in disadvantages, and it's called the spillover disadvantage. And for the negative, you should make it a primary argument that you want to run. The 1NC should read the shell for this in the 1NC, and the 1NR should go for this disadvantage for all. A quick note about files. So in the extensions past the shell, you will frequently see a block labeled AT, and that means answers to a given argument. So if it says AT, we don't grant personhood, that means it's an answer to the argument that they don't grant personhood. Those are what those extensions are designed to do. Some things to keep in mind. The affirmative is going to say they don't grant personhood, they just grant rights or duties. But our argument is that if an entity has a right or has a duty to something, that requires legal personhood. So legally, the artificial intelligence, or legally, the non-human animal, or legally, nature would have personhood status, which would set a precedent to give fetuses personhood status at the time of conception. They will also say the Supreme Court would not take this case, but the Supreme Court wants to rule on fetal personhood. They just don't have a good precedent to do it. If you force the Supreme Court's hand and said, we're going to grant personhood to artificial intelligence, the logical question a lot of people would ask is, if you're granting personhood to artificial intelligence, why wouldn't you grant personhood to a fetus? What argument are you going to use to distinguish those two? And it becomes difficult to come up with an argument as to why, say, artificial intelligence or a non-human animal deserves personhood, and the fetus doesn't deserve personhood at the time of conception. So your argument is that if they grant rights or duties to one of the three entities in the topic, that conservatives would have a precedent to grant fetal personhood, and fetal personhood would undermine the rights of people who can become pregnant. Now we're going to talk about topicality. In the negative section of the Dropbox, under topicality, you'll find our file that has a bunch of different topicality violations. You can run those violations that apply, but you can pretty much run vest means all rights against any case. And this is just like the novice packet topicality or T violation. You should probably not go for this unless they drop it. You just don't have to talk about it anymore. But if they do not answer it at all, you can extend topicality and win that it is a voting issue, and you should win the debate on that alone. And I know we've lost a couple of debates on topicality, which indicates the power of the argument. And this is found in the negative section under topicality. Now we're going to talk about artificial intelligence AFs. In putting together your 1NC for an artificial intelligence AF, you could include 1. Vest means all, 2. The fetal personhood disad, 3. The nearest person counterplan, which I'm going to talk about in a second or two, and 4. Some case arguments. You can look in the AI case negative under negative case negatives, and you'll find artificial intelligence negative. You'll also find military artificial intelligence negative, which is useful if teams are still running the packet affirmative. So the nearest person counterplan. Before we get into any of these counterplans, I want to clarify something. If they ask what the status of the counterplan is, say it is unconditional. If they say in the 2AC that conditionality is bad and they have not asked you what your counterplan is, say it is unconditional. You will go for the counterplan in the last speech. We have not talked about counterplans enough to get into the debate about conditionality, so I think it is much easier for you to say the counterplan is unconditional. We will go for the counterplan. Now, the nearest person counterplan is found under negative counterplans, nearest person counterplan. You might want to pause this video for a second and get that file and look at it while we are talking about this argument. So it's under the negative, it's under counterplans, and it's called the nearest person counterplan. The thesis of this argument is that you grant responsibilities for the AI to the people that use and benefit from the AI. You do not grant a right or duty to the AI. You grant the people that are responsible for the AI the right or duty to control the artificial intelligence. And if you held the people responsible, they would make sure that the AI was innovative in a safe manner, because if it didn't innovate in a safe manner, then you would have responsibility put upon the person. Some strategy tips. You do not grant personhood rights to AI, but you do encourage safe development of AI. If the developer was responsible for the artificial intelligence, then they would make sure to develop it in a safe manner. In terms of strategy, the 2NC should go for this counterplan and then answer their case advantages, just like we did against the packet AF for the novices. The 2NC would go for the confidence building measures counterplan and the answers to the two advantages, and then the 1NR will go for the fetal personhood disad. Just like you used to go for the economy disad, this time you're going to go for the fetal personhood disad, saying that they would give the fetus rights at conception. When the 2NR comes around, put the counterplan first in your order, the disadvantage second, and answers to the advantages last. And make sure that you flow and answer what the other team has to say against your arguments. Now we're going to talk about right to nature AFs. These AFs will grant nature the right to sue people who pollute or destroy nature. Now you might ask, how is nature going to sue somebody? And it's not actually nature suing somebody. An environmental activist would sue on nature's behalf. So an environmental activist would go to court and say, you polluted this river, you chopped down this forest, but that part of nature has the right to not be polluted. For the most part, these affirmatives claim advantages from the environment. They'll say things like they protect biodiversity, which means they protect species or ecosystems. They'll do things that say they stop warming or climate change, and those will be their advantages. A 1NC versus the right to nature could include T, vest means all rights or duties. Maybe they don't grant all rights or duties to nature. The Biodiversity Convention counterplan, which is under negative counterplans, advantage counterplans, which has the negative grant ratification to the Biodiversity Convention. There's an international convention that is designed to protect biodiversity or species and ecosystems, and we would have the United States sign on to that convention. And then the fetal personhood disad, and then answering the case advantage. The Biodiversity Convention counterplan has the United States ratify the Convention on Biodiversity. So the United States would be obligated to do things to protect biodiversity. The United States would be obligated to have money put towards protecting ecosystems and biodiversity, and we would be required to not do things that undermine biodiversity. It solves for species loss and ecosystem damage without granting rights to nature. And there's good evidence that says if the United States ratifies this treaty, that other nations would ratify the treaty, and that would solve for international species loss. The 2NC should take this counterplan and the case, arguing it solves for biodiversity while not granting nature rights, and the 1NR should take the fetal personhood disadvantage that's saying granting the right to nature would mean that fetuses would gain personhood at conception. There are also a lot of good case arguments versus the right to nature, and I really want to make sure you spend a good portion of your time answering the case advantages, particularly the solvency. And you may ask, well, what is solvency? Solvency just means whether or not the plan works. If the plan works, then it has solvency. If you answer the solvency and you say the plan does not work, then you've undermined the affirmative solvency. And that means that it would undermine every advantage. If the right to nature is ineffective in courts, then all of their environmental advantages would be undermined. So the 2NC should make strong solvency attacks versus the right to nature. We haven't been making very many solvency attacks in debates, except maybe that the affirmative doesn't solve for the law of armed conflict. But in this situation, we want to say you don't solve for the environment. And here are 3 reasons why the right to nature AF might not solve. The first is that granting a right to nature creates conflicting interests. So what do you do when some people say it is good for the environment to do this, while others will say something else is good. Let me give you an example. Invasive species. So trade has made it to where we bring species into environments that are not their home environment. So they're examples of certain species that have come to the United States which are not in their natural environment. Good example is kudzu. You may know of kudzu. It grows like it's a plant species that grows like crazy and takes everything else over. Now, kudzu is part of nature. Do we protect kudzu? Or do we say because it threatens other species and because it threatens other ecosystems, we need to have the right to kill kudzu? There'd be a conflict. Is it okay to harm certain parts of nature while helping other parts of nature? Or do you have to protect everything in the natural environment? The point is that these obligations conflict, and both lawyers and judges won't know what to do with these conflicting obligations. Second, the rights won't be enforced. Okay, as we talked about before, for nature to be protected in a courtroom, an environmental activist is going to have to sue on nature's behalf. But who do you think has the better, more expensive attorneys? The environmental activist or the oil companies? Obviously, the answer to that is the oil companies, who can afford to pay the best attorneys. And therefore, when it comes to court, these attorneys, they'll have a lot more of them, they'll have a lot more money to pay them, will beat back the claims of the environmentalists. And as a result of that, these rights to nature will not be enforced. A third thing to know is that these teams are going to try and claim that a mindset shift will occur. That if we grant the right to nature, we will then recognize that we are one with nature, that human beings are part of nature, and that we need to be protecting nature. I think this is a pipe dream. The notion that the head of Exxon or the notion that the head of Shell Oil is all of a sudden going to recognize that they are one with nature and they need to protect nature is relatively ridiculous. Even if you change the law, you're not going to change their minds, so this grand mindset shift they claim will not occur, which means the environment will not be protected. And I think you need to be aggressive against this and say, this is utopian. People in Alabama are not going to change their minds just because the courts have granted a right to nature. They're still going to think that they have dominion over nature. They're still going to think that nature is a tool that they can use, and they're not going to change their minds just because the law says one thing. Your other case arguments can be takeouts against the advantages. For example, you might say that warming is false, or that warming won't cause conflict, or that we're too far gone and we can't solve warming. And where you can find those answers is in the Sanford debate files, impact cores, impact defense for answers to the advantages. So you can find things like biodiversity answers. You can find things like warming answers. And by the way, if you're debating climate change, our answers are under warming, so make sure you go there to provide answers to that. You should have a very strong 1NC case attack, and the 2NC should follow through with it. And then in the 2NR, you should go for the counterplan, the disadvantage second, and the case third. So you would take your biodiversity counterplan, argue that it solves most of, if not all of the affirmative by protecting nature, but not giving nature rights, because if you gave nature rights, then conservatives would think you could give fetuses rights. And then after you go for the disadvantage, you go to your attacks on the case. Last, we're going to talk about non-human animals. A 1NC versus non-human animals could include T, vest means all, the human rights counterplan, the fetal personhood disadvantage, and then various case arguments. So I'm going to talk about the human rights counterplan. The human rights counterplan creates a human right to protect the environment, to not inflict animal cruelty. So we would say, because humans have the right to a safe environment, a clean environment, a healthy environment, then we should not inflict animal cruelty on animals. But it does not vest rights in the animal itself, which is where the disadvantage of fetal personhood comes in. The evidence in this section says it solves without fundamentally restructuring our legal system. The 2NC should take this counterplan and the case, arguing that it solves for the harms done to animals without providing them with fundamental rights. On the case, you can read that animal testing is good and it's under the biotechnology disadvantage. So it says we need to test on animals in order to develop cures for diseases. Now, lots of times the affirmative claims that they will lead to better research because animal testing undermines research. This argument says animal testing is good for research and we need to be able to test on animals to solve diseases. And that in the past, we've solved a lot of diseases by testing on animals. If the affirmative already claims disease, you can run this argument by saying that you would undermine disease prevention by not testing on animals. Second, the plan would be circumvented. Humans like their privilege and judges would not protect animals. Human beings do not think of themselves as animals. We think we are superior to animals, and therefore we're not going to protect animals even if the law says we're supposed to. And judges operate within a mindset that the world is human-centric or anthropocentric, meaning that human beings have dominion over animals, and therefore judges operating within that mindset will not protect animals. You also want to argue that the correct framework for the debate is utilitarianism, the greatest good for the greatest number. A lot of these teams will say you need to give animals a fundamental right and that you should never violate rights. And that's called deontology, the idea that you should never violate rights. But on the negative, we want to say you can violate rights if it leads to a greater good. So even if we have to test on animals to cure disease, the greater good is solving disease. You also want to argue that if you solve disease, you protect more animals. Don't forget that these diseases kill animals as well. Therefore, it is okay to test on animals because that will protect animals as well as humans. So some conclusions. First, learn to navigate the drop box. Practice with it. Make sure you can navigate it well. Second, before the debate, ask the other team what affirmative they are running. So you can ask them, what is your affirmative? What I would do is when you come in the room, introduce yourself to the other team, like, hi, I'm Ryan and this is Lee. What are y'all's names? And then say, oh, and what affirmative are you running? And ask them for their advantages. That is a protocol that exists in debate. You can ask them what they're running. Third, if you are asked when you're affirmative what you are running, say you're running medical artificial intelligence and your advantages. And fourth, put together your 1NC before the debate starts. Try to avoid using any prep time for the 1NC. Just like we were ready to go against the packet affirmative, you should be ready to go against the other team's affirmatives. Hopefully this will help, and I wish you good luck in your debates.